Hello, the authorized representative for Hackle is here.
Please turn your camera on, please.
Okay, I have to access it, so it might kick me out. So I'm gonna do it now.
That's fine.
Okay.
I know I denied the motion to set aside the default judgment back on August 21st. Defendant failed to appear.
Correct.
Defendant's motion to seek leave of court is denied.
We're showing a current, although this is a termination of tenancy for failure to recertify, we show a balance of in excess of $12,000.
Ms. Hackle, state your name for the record.
I am the authorized representative for Alicia Hackle.
I don't see your face. I'm sorry. I see your hat. Can you see your face?
Oh, okay, I'm here.
The camera's pointed at the top of your head. I can't see your face. All right. Mr. Hu, go ahead.
Yeah, thank you, Your Honor. A judgment was entered, a motion was denied, trying to set aside the judgment. Plaintiff is seeking a order of eviction for termination of tenancy. No payment has been made since March of 2024. We would ask that a writ be issued.
So the writ will issue and execute immediately.
Thank you, Your Honor.
I would like to say there's been a defective order of process.
Buckle up, guys. Today we're diving headfirst into one of the most delusional courtroom moments you'll ever witness. A so-called authorized representative tries to stop an eviction using sovereign citizen nonsense, and the judge isn't having a second of it. She dodges questions, misinterprets legal terms, and spirals into procedural gibberish, only to be met with firm legal facts. The moment the judge says, "You've been advised and failed to appear twice," you know it's game over.
I received the order of process for court today. I went down to the court today, and she gave me the documents for court today. There's also isn't a sign off by a judge on the document sheet that she explained to me that the judge didn't even sign the documents. I also never received a motion in the mail.
Well, this is an application. There is an application for eviction.
Yeah, there's an issuance for a writ here. I've actually never received that so that I could formally respond to it.
All right, so let me make a record. Give me 1 second.
Yeah, there should be some proof of service in the files for the case.
Well, hold on 1 second. 1 second. You were served with the summons and complaint. It was posted on the address by Chief Officer, Court Officer Juan Polanco. I believe he did it on July 20th, 2024. And then there was a default judgment entered against you by Judge Goubeau on July 31st, 2024. I believe you failed to appear. You didn't appear to that. And so that's how we get here now. Then you filed a motion to set aside the default judgment. Hold on 1 second. And you did not appear to the default judgment. So yeah, the writ in issue. So you've been advised of court and you failed to appear twice. Like I'm not understanding what's going on.
Actually,
so
all my documents. I've given all my documents. There was a judgment issued against me. And it was denied, but and then after that I hadn't received anything back for the case until I'm in court today about something that I had gotten no prior documents before I came to court today. I literally didn't receive any motion for issuance for a writ until today when I went to the court to get the papers. I didn't receive this by mail at all, so that I would have been able to respond to it before now.
Your Honor,
I have not missed any court dates.
Your Honor, I heard your ruling. Thank you very much.
All right. Thank you. We're all set.
Have a good day.
You too. Thank you.
All right, guys, here comes the return of Mr. Myrick, who who once claimed the roads belonged to him and now wants to backpedal through pre-trial with a new excuse. He drops the sovereignty rhetoric just long enough to question whether he's even been arraigned properly. Classic delay tactic: question jurisdiction, claim Fifth Amendment violation, then act surprised when the judge expects structure. But watch how calm and surgical the court remains under pressure.
So basically at this point in time, it's a pretrial. So I would set you up with a breakout room with the prosecutor to see, what their, if they have any offers or what their story is. I just want to make sure when you go in there, like, you don't have an attorney with you and they're the attorney on the other side. They may give you an offer that you like, and that's fine. But I just want to make sure that that at any point in time, if you don't like the way the conversation is heading, if you change your mind and you do want to come back and ask for an attorney, just come back and let me know. Okay.
Okay. Before I get into the breakout room, Your Honor, I do want to address, we are in the pretrial stage, and in the arraignment stage, I was entered a plea involuntarily. So I would love to have an ample amount of time to draw a meaningful defense. If anything, there was some questionable things that the last judge mentioned that I haven't found at all as far as a statutory jurisdiction. But I would like to have time to draw a meaningful defense as well.
Okay, so do you not want to meet with the prosecutor then?
Well, I don't think it's completely prudent right now, simply because we haven't technically went past the arraignment stage of this process. I feel as if my due process has been violated. Fifth and 14th Amendment. I didn't enter a plea, and here we are in pretrial. So I would like to kind of digress a little bit and have at least enough time to develop a meaningful defense.
Okay, I guess I'm a little confused. So you had an arraignment date, and
Yes.
at that arraignment date, did you refuse to enter? Did you refuse to enter a plea? Because that's the time where a plea of some sort has to be entered. So at that point in time, did you, of your own volition, say, I'm not saying anything at all?
Well, that wasn't totally the case, but I didn't have understanding of what court I was in, and I didn't understand if it was a criminal jurisdiction, civil jurisdiction, and based on the at least the federal laws for sure.
This is where things take a wild turn. The judge hits Mr. Myrick with the ultimate contradiction. How did he know how to log in if he didn't know what court he was in? The sovereign script starts to unravel fast. The judge exposes every gap in his story with pinpoint logic, walking him step by step into his own contradiction. When the court points out he never paid the bond but still showed up again, the whole charade starts collapsing in real time.
Say that again, Your Honor.
How did you know, like, for the arraignment, like, oftentimes when there's an arraignment, that happens when someone's been arrested and they're sitting in custody, okay, or if they've received a ticket or some sort of notification. So you just said to me that you didn't even know what court you were in. So I just want to know, like, how did you know how to get here? How did you know how to zoom in? Because the Zoom information contains all of our, like, what court it is, what magistrate, like, all that's contained in there. So I just, how did you know otherwise?
No, I did receive a ticket, and I got notice. But what my issue was appearing here on special appearance today, and I needed to get understanding of what jurisdiction I was in.
Okay. All right. So because I definitely want to make sure that people know where they're supposed to be. So I think I'm looking at the same ticket that you had. So it says on the ticket, 44th District Court, Royal Oak. And then the court address is on there. And then you said that you received notice. So the notice that went out, it would have had the Zoom instructions. Again, Mr. Myrick, as you can imagine, we are I'm always very concerned in making sure people have the proper notification and all that. So it does
Yes, sir.
appear that, I mean, you're here a second time. The only
Yes,
thing
sir.
that I was, now looking at the file here, you were ordered to post a bond and you didn't. Now, that was, I'm reading the notes here. It says, there was a bond of 1,000 cash surety, no 10%. So $1,000 bond was expected to be paid within 48 hours. Now, Mr. Meyer, we're here today. You showed up on time. So one of the reasons that a bond is ordered is, one, for the safety of the community, and two, to a secure appearance. Well, you come here a second time, and so I am very comfortable that you are going to continue to show up. So I, at the very least, for you, Mr. Myrick, today, as long as you continue to abide by the expectation that you'll show up, and you have twice now, I'm going to actually amend that bond. So even though you were supposed to do
Thank
it
you,
within
Your
40
Honor.
hours and you didn't, okay, the fact that you showed up here again, at least to me, is enough evidence to
You're not going to believe this one. After all the grandstanding, Myrick learns that fixing his license issue might only cost him, get this, $45. The judge even explains how their Operation Drive program restored 1,700 licenses, and you can see it hit Myrick like a freight train. It's like watching someone slowly realize the whole sovereign citizen identity crisis was over a bill smaller than dinner at Applebee's. This part is gold.
Have any discovery. I don't have any. I don't have what I need to assess to move forward. So if I can have more time,
I have no problem adjourning the pretrial so that you could do some more information gathering.
yes, sir.
Just to let you know, Mr. Myrick, again, like our court, as you can imagine, with 696-75 Woodward, we have a lot of traffic misdemeanors that come through this court. And one of our signature programs that we've been doing for the last 8 years is, trying to really help people, because I would imagine that you pay attention to the challenges of the Metro Detroit area and public transportation issues and people's ability to get around, and how many people over time have got themselves in the cycle of, they have to drive, but they pick up a ticket and they can't pay that ticket. So the license gets suspended and they get stuck in the cycle forever and ever and ever. Okay.
Yes,
Well,
sir.
in our Operation Drive program, what we've done over the last, now we're in the last 8 to 10 years, we've keeping stats since March of 2016. So in the last 9 years, we're over 1,700 licenses restored. So like, that's something that we try to do, is make sure that we inform, educate, get people the information that they need, which, Mr. Myrick, you could probably imagine, for years and years, the court system hasn't been great about letting people know even where to start, how to get their license. So
Yes,
in the
sir.
meantime, while you're doing your investigation, I at least want to let you know what's on your record so that you can at least know, because some people don't even know like where to start, how to go, or what to
Yes, sir.
do. And the
And
law
I
has
greatly appreciate you.
and the law has changed in a significant way. It used to be that every single little ticket that you'd get would suspend your license. Now it's only a couple tickets here and there that do that. So
I'm very honored, Your Honor, to be in your courtroom. I think you're the one that I've heard so much good news about, goodwill and good-hearted judge, that assists the public to oppose to.
Now this is what courtroom reform looks like. The judge offers help, gives Myrick resources, direct court contacts, and even assigns someone to walk him through the reinstatement process. Myrick drops the act completely and starts cooperating. The court bends over backwards to help him fix his life, proving that despite all the chaos, the system still wants to help people who are willing to help themselves. It's a full circle moment, unexpected, but powerful.
Thinking it's an NPOI?
yeah, it should be an MPOI.
All right. Because there
No
are
proof of
tickets, all of
insurance.
which are showing 45s. So
Really?
Yeah. So let me look at the second one. Sorry, it's taking so long.
That's right. That'd be great
All right.
news, because that'd be just $45.
No proof of insurance. This one was a default judgment. It is showing $45. But it is showing a bond that you posted, sir, back in 2009 of $398. I think they took that, so perhaps they applied it to that fee, and they just want the 45. That may be the answer on that one.
Okay, so best case scenario, they'll let you just pay the 45. Okay. Worst case scenario, they'll want the $45 on each of the old tickets. So 135. So best case scenario, 45, worst case scenario, 135. But that's Allen Park.
Wow, that's great.
And that's 24th District Court, sir, if you're looking it up.
24th District.
And it's interesting because these are very old cases, but the close date on the third ticket is 2017. And now I'm getting error readings. So, but there's just 3. Looks like you had your bond taken on the no proof because perhaps you didn't go back, and that may satisfy that.
All right, so Mr. Myrick, so here's what we're going to do. I'm going to bump this out a couple weeks. You get to work chopping away at that kind of stuff, but I will say this. I only want to bump it out a couple weeks because if you get those things done, all right, I want you to come back and see me. We'll be able to run a new driving record. We'll see if by doing that, all right, that they follow through and let the Secretary of State know, because if they take your money and they don't let the Secretary of State know, then the suspensions remain. And then we can even contact the Secretary of State and just make sure that they know, like, oh, by the way, he paid those.
Right.
And then when you come back here, you can give me an update. But just know, if you've paid those 2 tickets, you should be able to go into the Secretary of State and pay the reinstatement fee and go from there. So what do you think? A couple weeks?
Safely to say, I would say 30 days. If I can have the grace.
No problem. No problem.
Thank you, Your Honor. I appreciate you dearly too. Thank you very much.
You're welcome. All right, so we'll adjourn this 4 weeks, and we'll send notice again. And then just do me a favor, Mr. Myrick, if you run into issues, I'm gonna send you our direct line here at the court.
Thank you very much, Your Honor.
And for example, if you do decide, if you're running into issues, I certainly can connect with Mr. Angot, Ms. Chappelli there. Mr. Angot's our MIDC coordinator. I know that you initially were not inclined to go with assigned counsel, but what Ms. Chappelli's doing today is exactly what would be done. So if you just reach out to us, let us know, like if you're running into brick walls and you say, like, I would like.
Strap in, because this is the shutdown of the decade. Ryan Hart shows up trying to play sovereign games with names and strawman theory, only to get steamrolled by Judge Colin Hunter. The judge dismantles every trick, every buzzword, every dodge, and exposes the dangerous consequences of self-representation by someone who doesn't understand the law. Hart barely speaks, but when he does, it's like watching someone walk into a legal buzzsaw. This is courtroom discipline at its best.
Thomas Seeger appearing on behalf of Mr. Hart.
I have somebody in my hearing room listed as Ryan Hart. State your name for the record, please.
My name is Ryan John Family Hart.
I don't have anyone on my docket listed as Ryan John Family of Hart. I have an individual listed as Ryan John Hart. That's either you or it's not. You get to tell me whether or not that's your name. If it's not, then I need to call a different matter and bring somebody else into my hearing room.
Your Honor, I'm the representative of that entity, yes.
That's not an answer, sir. Your name is either Ryan John Hart, in which case you're invited to participate in the proceeding today as Ryan John Hart, or you're not Ryan John Hart, in which case I have no use for you to be in this hearing today. So tell me your name so that I can determine whether or not you're the proper person to be called in this case.
This final blow is poetic justice. The judge warns Hart, next time he pulls these antics, he won't be logging in from home. He'll be sitting in jail. And just when you think the court's done, the prosecutor reveals a plea deal that could save Hart, if he's willing to act like a grown adult. This part is the perfect ending to a trilogy of sovereign delusions. Like the video, subscribe for more courtroom chaos, and we'll see you in the next video.
Of the court to be able to proceed and to conduct its business. That's relevant to a lot of points, but most importantly, it's relevant to a pending motion that your attorney filed, presumably on your behalf, but I sense that it's not only on your behalf, it's also on your attorney's behalf. And so we're going to take up that motion. But your difficulty in basic things like telling me whether or not you're the party to a case is thwarting the court's ability to timely get its business done. I'm turning to the motion now that's before the court today, which is a motion to have attorney withdraw and to have you represent yourself, Mr. Hart. The court does not find that motion to be well placed, and I'm not going to prevent it. And the reason is there are several steps that need to be taken in order for you to be able to assert your right to represent yourself. First and foremost, I must find that your assertion of that right is unequivocal. I don't have that. What I have is your attorney's motion. And I recall very clearly and plainly the last couple of hearings that we've had. A couple of hearings ago, I had findings that I made based upon a competency and criminal responsibility examination. You were found both competent and criminally responsible by the court after assistance from the Center for Forensic Psychiatry and after an in-depth intervention and interview by them. I made the findings, your attorney agreed with them, and the prosecutor agreed. I have not once heard you make any type of unequivocal request at all. What I instead heard when I consider whether or not there's an unequivocal request for you to represent yourself is your attorney explained to me, I think this was 2 or 3 hearings ago now, that he was somewhat conflicted. And these are not his exact words, but this is what I recall from it. He was somewhat conflicted. You had wanted him to file various different motions, which the attorney did not find were supported by law. And the communication that I had in response to Mr. Seeger, again, was some version of this. I told Mr. Seeger that as the attorney, he and he alone chooses which motions are to be filed and which are supportable by fact or by existing case law or by the extension of existing case law. If he can't make those arguments that are good faith supported by law or an extension for the law, then he's not permitted to file the motions. It was at that point that Mr. Seeger then suggested that another solve for him could be that you could represent yourself. In other words, the implication that what Mr. Seeger was making is that if you were representing yourself, you would not be constrained in the way that he is. It would allow you to file whatever frivolous motions, I'm using that word, Mr. Seeger didn't.
Oh no, Judge.